Welcome back to the channel, everyone. Good to have you here, and I hope you're all doing okay. For anyone new to the channel, welcome. I'm Cal, and I'm here to educate you on your basic legal rights, which no one else seems to be doing right now. And today, I'm going to teach you how to successfully dispute a debt that you don't believe you own, and hopefully stop getting illegally harassed. Let's get straight into it. So I assume for many of you watching, you have or are currently receiving letters or communications demanding money that either you disagree with or that you are completely unaware of. Now, it is worrying, isn't it? Let's be real. But I learned a lot about debt as a commercial litigation paralegal years ago, and I can tell you convincingly that's a huge amount of debts are pursued in error. Do not go through life on the assumption that the system is perfect and that you owe whatever people say that you owe. That's just a basic life lesson. Now, in the UK, it's estimated over 1 in 10 debt collection letters are sent in error to the wrong person for the wrong amount or for a debt that's not legally enforceable. According to the Citizens Advice Bureau, nearly half of the people contacted by the debt collectors are also treated completely unreasonably. For example, aggressive letters, misleading threats, or tactics that border on bullying, right? That is not okay. I've dealt with this issue for people for years in my career, and today I'm going to help as many of you as I can. So in this very short video, I'm going to walk through step by step how to properly dispute a debt that you don't recognize or that you don't believe is fair, and how to do it legally and effectively. You'll learn how to make the creditor do the work and actually prove it, and also, extremely importantly, how to protect your credit record, because we do not want any adverse records on there, do we? And finally, how to avoid the common traps that people accidentally make by admitting to a debt that's not even theirs. And the best bit, as always, guys, I'm going to do it all in just under 9 minutes. So pay attention and let's learn something useful. Okay, first things first, you've had a letter or an email or a phone call saying that you owe money. Maybe it's from a company that you've never dealt with before, or a debt collection service. It might even be from a law firm threatening court action. Do not pay it and do not admit to the debt. Not yet, anyway. If you pay first, then argue, things will get far more difficult, guys, because the minute you say, I owe this, or worse, if you make a payment, even a small one, you could be resetting the clock on that debt, or confirming it as legally valid. And if it's not actually yours, that could make things a lot harder to undo later. Instead, take a breath, look at what you are dealing with. All right, so step 2 then. Who is asking and what are they asking for? So you need to check who's contacting you. Is it the original creditor, i.e., the actual person or company to whom you supposedly owe money, like the bank or a utility company or a builder, for example? Is it a debt collection agency, or is it a claims management firm or a law firm? Now, here is something you probably didn't know. Debt collectors often buy old debts for pennies and then chase hundreds of people in the hope that some will pay up, even if they don't actually owe the money. That is the reality, unfortunately. And sometimes it's not even your debt. Maybe it belongs to someone who used to live at your address. Maybe your name is similar to someone else's. Previous address owners' debts are such a common cause of this. Check it is definitely you and definitely not intended for the previous occupier of your property. I had letters myself from an energy provider, my energy providing company, at my current apartment where I live now, asking for overdue energy payments, but they were just titled as occupier. I could have paid it myself, but after a little bit of investigation, I knew it belonged to the previous owner of that property. Now, on to step 3 then. You're going to send a prove it letter. All right, step 3 is where you start to take control yourself. You're going to write what's called a prove it letter. It's simple, it's easy, it's powerful, and it stops the pressure in its tracks. Now, here is what it should say in plain language, and you can copy this bit if you want, or to be honest with you guys, you can just get ChatGPT to write this for you. It's not a legal document and it will do a pretty good job. But something like, I do not acknowledge any debt to your company. Please provide a full breakdown of the debt and evidence that I am legally liable to pay it. Until this is provided, I will not be making any payment or further correspondence. That is it. Keep it firm, polite, and factual. Send it by email and record a delivery if possible. And importantly, Do not sign it, guys. Do not sign it. Just print your name. Some people I've heard have had their signatures copied or misused. That's just a little inside tip. And like I said, save copies and make sure it is recorded delivery so you've got a paper trail. Now, once they get this, they are legally required to stop chasing you until they provide proof. And by proof, I don't just mean them saying, oh, you owe it. They'll need to show the original agreement, which apparently you signed, the full history of the account, and that they have the legal right to collect it from you. Then in our next step, we will deal with their potential responses. All right, step 4 then, their response. Here is what might happen. Number 1, they go quiet. That's a win for you. It means they couldn't prove it, and this happens far more often than you might think. Or number 2, they send vague paperwork back to you. That is not good enough. They need the full agreement and a proper statement of the debt. The third thing they could do is send proper proof. Now, look, at this point, look closely. Ask yourself, is the debt in your name? Is the amount correct? Is the debt, and this is important, is the debt over 6 years old with no payment or written acknowledgement? That could make it statute barred, time barred, which means that they can no longer legally enforce it in court. All right, so let's say they've sent you proper proof. Let's move on to step 5, which is to check the charges and challenge unfair costs. So let's say the creditor does send you proof of the debt, but the balance seems way too high. Maybe you remember owing something like £150 and now they're suddenly demanding £500. That's not unusual, but it is something you can challenge. You have the right, as I said before, to ask for a full breakdown of the debt, especially if it's regulated by the Consumer Credit Act. Now that means they should send you a full statement of the account itself, a clear list of all the charges, fees, and interest that's been added so that you can see, you can calculate how they came to that figure. Now, sometimes the original debt was small, but then what they'll try and do is these debt collectors, they'll try and then tack on extra fees for letters or missed payment fees or administration fees. But here is the thing, those charges have to be reasonable and fair. For example, if they're charging you £50, as an administration fee just to send a letter, you can question that. In most cases, they are only allowed to charge what it actually costs them to carry out debt collection action, not to use it to punish you or to profit from you. So read the terms and conditions if you have them, and if the numbers do not make sense, ask them to explain first. And if they won't reduce the balance, if they're refusing or you do not agree with their reasons, then you can make a formal complaint. But look, let's be real, guys. That's, in my experience, a formal complaint's not really going to do much. Let's take it to the Financial Ombudsman Service instead. Now, I would recommend going to the Ombudsman Service if they've ignored you for more than 8 weeks, or after review, their final response isn't fair to you. Now, the Ombudsman can't decide whether or not you owe the debt. That's important. But what they can do is they can rule on whether the creditor is behaving fairly and lawfully. And if they're not, the creditor might be forced to write off part of that balance or remove any of those unfair charges altogether. Now, though, it would not be very prudent of me, would it, not to discuss the next section, which is if they do threaten court action. Now, sometimes they might push further, okay? Especially if they think you're not going to respond. So if you get a letter before action or a county court claim form, do not ignore it. Do not ignore those things, guys. Ignoring a letter can be extremely harmful. It can lead to a county court judgment, a CCJ, against you by default, which damages your credit rating for 6 years. If it is a real claim form from the court, deal with it. You'll have 14 days to respond. You can either file a defense of your own saying, I don't owe the debt, and explaining why, or you can ask for more time and request the evidence again through the route of court action. If you are in this situation, in my experience, I would say that you can and maybe should get help from a solicitor or a service like National Debtline or Citizens Advice. They are all free services and they're fully confidential. But again, guys, listen, if they can't prove it, if you doubt their ability to prove it, then they usually won't even go to court. They probably know, your creditors probably know, that a judge will not side with them without solid evidence, okay? And now quickly, in my final section, I need to explain this to you. What to do if it appears as an adverse entry on your credit report. We do not want that, okay? So if a debt you don't recognize is somehow already sitting on your credit report, that is serious, but still fixable. Start, number 1, by checking your report for free with one of those credit score agencies out there. I used Experian when I was having issues with mine, but I think there are others out there such as ClearScore and Credit Karma. Now, very important, you can dispute the entry directly with those credit reference agencies, okay? You can do it directly with them. If the debt is not in your name, for example, already paid, over 6 years old, or was never actually proven with any documentation, then they are required to investigate it and remove inaccurate information within 28 days, okay? Unless, of course, the creditor can provide proper proof. And guess what? If the creditor can't back it up, they can't keep it on them. Finally, I want to mention harassment to you guys. I know many of you out there watching believe that you're actually being harassed over the supposed debt, and that is obviously another claim in itself. And in my experience as a lawyer, harassment does need certain elements or requirements in order to qualify as harassment. So let's take a very quick look. Now, let's be clear, creditors are allowed to contact you about a debt. Yes, they are. But if they're calling you repeatedly, contacting you at unreasonable hours, or making threats or anything like, trying to embarrass you by telling your employee or members of your family, etc., that is harassment, and it is against the law. Now, listen closely. For a harassment claim to succeed, it usually needs to show a pattern. That's the operative word here, pattern of behavior, not just one annoying letter, but repeated excessive contact that's designed to intimidate or distress you. If that keeps happening, keep a record of every single piece of communication, every call, every message, every letter, report it to the Financial Conduct Authority, the FCA, or the Financial Ombudsman Service, which I mentioned earlier. They have the power to deal with this, but you can also, if you want, if it is serious, you can also speak to a solicitor about that. Now, guys, if any of you out there are worried about debts and your ability to pay them off, please listen before I say goodbye. I've done an incredible 10-minute video right here on the topic of what to do if you cannot pay your debts, where I cover all your legal options and your non-legal options to help you wipe your debts for good. That video is linked right here and in the description below. Look, guys, I really want to hear from you on this topic. I want to know your stories and your experiences with disputing debts or being falsely accused of owing money. Which route did you take and how did it go? And did anything go wrong? Do you have any tips for anyone else watching? Let's get a discussion going down in the comments so we can all help each other. Now, if you have liked, learnt, or taken anything of value from this video I have made for you today, do not forget to subscribe. Remember, this content is educational only and is not a substitute for personalized legal advice. That said, I'll see you in the next video.